Good afternoon, everyone, and welcome to our Lunch and Learn session, Trick or Treaty. I'm very happy to introduce you to Jean Becker, Senior Director of Indigenous Initiatives. Over to you, Jean.
Again. Welcome, everybody. Thank you so much for joining us for Treaties Recognition Week here at the University of Waterloo and for learning with us. I'd like to start off with a territorial acknowledgement. We acknowledge that the University of Waterloo is situated on the Haldimand Tract, land and territory that was promised in a legally binding treaty to the Haudenosaunee of the Six Nations of the Grand River. The land inside and outside of the Haldimand Tract is the traditional territory of the Neutral, the Anishinaabe, and the Haudenosaunee. Thank you for joining us and learning more about what is behind these territorial acknowledgements. I would like to welcome and introduce today's presenter, Dr. Susan Roy. Dr. Roy is an associate professor in history here at the University of Waterloo. Her work aims to deepen public understanding of colonial history through research, disciplinary projects that amplify the voices of First Nations communities and artists. She has over 20 years' experience working for First Nations in relation to Indigenous rights research and community initiatives. Thank you so much, Dr. Roy, for leading Day 2 of the University's Treaty Recognition Week event series and for bringing forward your experience, your knowledge, your hard work, for sharing with us. Thank you so much. Over to you, Dr. Roy.
Great. Thank you, Jean, for that wonderful introduction. I'm really excited to be here today to share in the university's first Treaty Recognition Week. And I'd like to thank the organizers for this week and also the other presenters and all of you who have taken time today to learn and engage in this important conversation. So I'm just going to share my PowerPoint and get started. Sorry, I have to flip back to the beginning here. You get a sneak preview there. Okay, so when I was thinking about this week in today's presentation, the organizers asked me for a title for my talk today. And so I thought about Trick or Treaty in honor of Halloween that has just passed, but also I remembered about the important film Trick or Treaty, which is the name of a 2014 documentary by Abenaki filmmaker Alanisa Bomswin. So this is a film that was created during the beginnings of the Idle No More movement in Canada, and it's specifically about the experiences of Treaty 9 communities in Northern Ontario. Those Cree and OG Cree communities of James Bay. Treaty 9 covers a vast part of our province. And it's about those communities asserting their treaty rights while also exposing the complexities of contemporary treaty agreements. So I really recommend this film to you. I'll be showing a short clip of it towards the at the end of my presentation today. So today I'll be talking a little bit about what is a treaty, and I know that Jean Becker mentioned this in her introduction to the week yesterday. What are some of the historical contexts of treaty making in Ontario and Canada more broadly? And what are some of our contemporary responsibilities as settlers in Canada to these treaties? So you may have heard of this phrase, "we are all treaty people." What does that mean? What does that mean in the Canadian context, especially when we have some parts of Canada that aren't covered by treaties? This is a photograph of two young Mi'kmaq community members during the height of the violence that was directed towards the Indigenous lobster fisheries in Nova Scotia over the past month. And the Mi'kmaq lobster fishers only hold approximately 1% of lobster traps in these eastern fisheries. But you will have seen on the news recent reports of the violence of cutting and stealing Mi'kmaq lobster traps, shooting flares at Mi'kmaq boats, burning lobster pounds. Non-Indigenous fishers, commercial license holders, claim that the Mi'kmaq are fishing illegally out of season, and the lobster fishery is from May to November. But the Indigenous lobster fishers are asserting their treaty right to fish at this time of the year, and they point to the 1999 Supreme Court of Canada decision, R versus Marshall, which held that Mi'kmaq man, Donald Marshall Jr., had the legal right to fish for eels out of season. According to the treaty, his rights were affirmed in the Treaty of 1752 and the treaties of 1760 and 61. So the Supreme Court emphasized that the Mi'kmaq have a treaty right to earn what they called a moderate living from fishing. And so thinking about what does that mean in this contemporary modern day standards. So what is a treaty? This is an image of two wampum belts. And usually when I'm teaching in my classes, when we're talking about treaties, I show the students a picture of wampum, and these days about half the class have seen wampum, which is really exciting. But the top picture is an image of a two-row beaded wampum belt. And below is the Silver Covenant chain wampum. And these are belts that are woven from the valuable purple wampum shell in Haudenosaunee and Anishinaabe traditions as a material representation of a treaty or an agreement between two or more sovereign nations. But these are more than a representation of a treaty. They also represent a living treaty or a living history, as Jean also mentioned yesterday, thinking about treaties as living documents. So according to the Onondaga Nation's explanation, they say that the shell is thought of as a living record of the Haudenosaunee. The speaker puts the words of the agreement into the wampum as the strings or belts are woven together. Each speaker thereafter uses wampum to remember the initial agreement and the history that has happened to date. To us, belts are our living histories. So the two-row wampum was first used in the early 1600s, or it was documented in the early 1600s when the Haudenosaunee first met the Dutch as an agreement between those two nations. So the two purple rows running alongside each represent two boats. One boat is a canoe representing the Haudenosaunee and their way of life, their laws, culture, language, traditions. The second row, it represents the Dutch ship with their laws, traditions, language, religion, governance, and people. And the idea is that the boats travel side by side out down a river, not interfering with each other. So between the two rows of purple beads are 3 rows of white beads representing friendship, peace, and respect. And in other descriptions, they talk about the relationship lasting forever. So the belt embodies this set of rules or guidelines governing the behavior of the 2 nations, stipulating that neither group will force their laws, traditions, customs, or language on each other, but they will coexist peacefully. So these principles, these values form the basis of numerous treaties and agreements between Haudenosaunee and other Indigenous nations, and also Haudenosaunee or Indigenous nations and European arrivals, newcomers. The bottom belt here is an image of the Covenant silver chain, and it is an example of a belt between the Haudenosaunee and the British Crown. So it depicts the 2 nations connected to each other with a silver chain. The idea is that you have to keep that chain polished, to keep that relationship alive, and that those 2 nations are bound to each other in this relationship of mutual respect. So, you know, a representation of that nation-to-nation agreement. So I wanted to show you this letter, which is in the collections of the National Archives, and it's a letter from 6 Nations members, so Joseph Skye, Lucinda Bonberry, Maggie Williams, and Elizabeth Fish, who are writing to His Majesty King George V of England in 1917, so it's during World War I. And they are writing to ask that their sons, who they say were not of age, but had enlisted in the King's army anyhow, they're writing to ask that they be sent home from the war. And what is really interesting here is that they've inserted into their letter these images of those 2 wampum belts, of the Covenant silver chain and of the 2-row wampum. So they're really pointing to and reminding the British of their responsibility as allies, and that and to follow those nation-to-nation agreements. So of the Covenant silver chain, they say that the British are at war, and according to this treaty, this agreement, if the British need help, they should write to the Governor General in Canada, who should then ask the 6 Nations lords or chiefs to call upon their war leaders and to help the British in their war. So they're really pointing to that agreement as a nation-to-nation agreement. They also insert the 2-row wampum into this letter, saying that, quote, it signifies 2 separate governments that exist, and that they shall exist independently from each other forever. And 6 nations shall not rule over the British nation, and the British nation shall not rule over the 6 nations. Six Nations historian Rick Hill has described these belts and the protocols and values that they represent, that they acknowledge each other as allies, and that they are meant to inform each other about issues of concern. They offer expressions of condolence. They seek justice on a variety of political and economic matters, that they renew peaceful relations, and that they agree on a course of action that is mutually beneficial. So thinking about treaties from an Indigenous perspective, you might be asking, well, what is the perspective historically of treaties from a European Western settler perspective? How is it that settlers came to these lands and claimed Canada, so-called Canada, as their own? So this is a really interesting question, because it also we're thinking about how Europeans claim this land, which completely didn't pay any attention to those long-standing Indigenous traditions, relations to land, systems of governance, and connections and ownership of territories. So here, the Doctrine of Discovery, you might have heard of the papal bulls which put out this Doctrine of Discovery. which was codified by a Spanish legal philosopher in the 16th century, Francisco de Vitoria, who set out these guidelines according to European law. I really want to stress that this is, European law. This has nothing to do with how Indigenous people understand their connections to land. Set out these guidelines of how monarchs could claim newly so-called discovered lands through this act of discovery. So according to European law, Indigenous title, ownership, connections to territory could be extinguished through three ways. The first being terra nullius, which is means that idea that the land was empty or that the land was abandoned through conquest. And I love this cartoon because I think it's like such a great explanation of that notion of terra nullius. The idea through conquest, that a just war could be waged on so-called infidels, using the language of the time, that people who don't believe in God could be subjected through conquest, which we see in Latin American countries, or if sanctioned through negotiations that led to a formalized treaty acknowledging a land sale. So again, of course, I just want to really assert that this isn't paying attention to those long-standing Indigenous traditions, governance, systems of diplomacy, connections to territory and land, ways that Indigenous nations organize themselves in terms of lands and resources. So if we fast forward to 1763, the Royal Proclamation of 1763 that Jean also mentioned yesterday, this proclamation set out the terms for governance of how the British Crown would manage land in North America following the 7 Years' War. So in 1763, King George III of Great Britain issued this proclamation saying that the land west of the proclamation line, which you can see on this map on the left between the light pink and the hot pink there, until the Crown, the British Crown, has signed treaties with Indigenous nations who occupied those territories. So while the proclamation is this recognition of Indigenous sovereignty and title and ownership of the land, it also placed the British Crown in that role of being the ones to negotiate those treaties. The idea from that British Crown point of view is that Indigenous nations would surrender their title to the British Crown. So it's really, you can't really understand the Royal Proclamation, however, without considering the Treaty of Niagara and the wampum and those oral agreements that were integral part of those treaties. So I'm just going to play a clip of Alan Corbière. And this is a clip that's on display at the Canadian Museum of History in Hull. Alan Corbière is an Anishinaabe historian, an expert on wampum, and a professor of history at York University. And here he's described, there are two very short clips, and he's describing wampum and a treaty medal as an integral part of these treaty negotiations. So,
The Covenant Chain is a long-standing treaty between Aboriginal people and the British Crown. Lawyers today look at the Royal Proclamation as the Magna Carta of Indian rights in Canada. Anishinaabe people look to that wampum belt of 1764 that was given at the Treaty of Niagara as our Magna Carta of Indian rights. We believe that wampum was given to the Native people to remember things. And the figures that are on there serve to remind us of all the promises that were made. the British recognized that we owned the land, and they had also said that we were autonomous and they accepted our sovereignty. And that's why on the belt you see that there are two people there standing side by side as equals. The medal that you see before you is a large silver medal that was given by Sir William Johnson at the Treaty of Niagara. You see, of course, that it's a circle. The clasp on there forms a pipe and an eagle wing. This is called a calumet. Whenever the chiefs gathered, they would always smoke the pipe. And of course, a calumet is a large pipe. And these calumets had the tail feathers of an eagle on them. This medal itself is a mnemonic device of the promises that Sir William Johnson had made. It's a codification of the covenant chain. Two people are sitting under a tree. One represents a native person and one represents a British person. The idea is that these two are smoking under a tree in peace. So that's what this medal that you're looking at represents. It actually is a part of the Treaty of Niagara, and it goes along with that wampum belt that you will see also in this display.
Okay, thank you. So you hear Alan Corbière there speak about the emphasis on those nation-to-nation agreements that respect the sovereignty of the Indigenous nations, but also that the treaty is more than the written document. So it's more than the Royal Proclamation alone, and we can't understand that without understanding the context of the negotiations, the wampum, the treaty medals that are devices that also, the oral histories that also represent those larger discussions and negotiations. So as we, and if you're interested in learning more about wampum, I really recommend, there's numerous interviews and presentations by Alan Corbière, who's from Manitoulin Island, and also Rick Hill of Six Nations, talking about wampum, who are very much experts on that history. So moving forward to historic treaties. These are treaties that were negotiated between 1701 and 1921 in Canada. So there's quite a complex history of treaty making in Canada, and I just want to spend a little bit of time looking at some examples of historic treaties. This map comes from the Ministry of Indigenous Relations website, which shows the treaties negotiated between this period, including the treaties of peace and neutrality from 1701 to 1760, peace and friendship treaties, the Upper Canada land surrenders and the Williams treaties, which cover the area that we're residing in, the Robinson treaties of Ontario, and the Douglas treaties, which are a few of the treaties that were negotiated in British Columbia. The province remains untreated, most of the province. And then the numbered treaties of Western Canada negotiated between 1871 and 1921. And again, it's important to understand the context of these treaties, that they are more than the written documents, and that learning what was discussed during their negotiations and how Indigenous signatories understood those treaties as an ongoing relationship and not mechanisms for surrendering their rights or ownership of land. Just turn it, there we go. So an important treaty for the University of Waterloo is the Haldeman Tract, 1874. Phil Montour will be providing information about the Haldeman Tract in his presentation tomorrow. But this was land that was granted to Six Nations following their participation in the American Revolution. That encompasses 6 miles on either side of the Grand River. It was originally 950,000 acres, was set aside, and today approximately 40,000 acres remain as Six Nations Reserve in the southern portion here south of Brantford. So again, you'll be hearing from Phil Montour of Six Nations, and also Chief Stacey Laforme of the Mississaugas of New Credit, who will speak over the next couple of days about treaty histories in this area. So I just wanted to turn to the numbered treaties, which cover Northern Ontario with Treaty 9, which I've mentioned, but also extend across Western Canada, leaving British Columbia largely an area that where treaties have not been negotiated. So in 1870, the Hudson's Bay Company, this is like your really quick, like 1-minute treaty review, but the Hudson's Bay Company sold Rupert's Land. So the Hudson's Bay Company had a charter for exclusive trade within the lands that all drained into the Hudson's Bay. So Rupert's Land was largely kind of considered to be around here. So they sold their rights to Rupert's Land to the British Crown for £300 without any consultation, negotiation, or process of discussing that sale with any Indigenous or Métis nations in those lands. So this was part of this process of bringing the Northwest Territories bringing the Canadian West into the Canadian Confederation as well. So at that time, the Canadian government promised on behalf of the British monarch, the Crown, to negotiate with Indigenous peoples for the titles, so their ownership to their territories, and the setting aside of Indian reserves. So here you have the state considering those treaties to be extinguishment as part of the process of extinguishment of the removal of Indigenous title to those lands, of paving the way for Indigenous settlement, for non-Indigenous settlement. So you'll recall that the Royal Proclamation created that Indian Territory in the West and stated that the British Crown was to negotiate with Aboriginal peoples prior to settlement. So this was what was motivating the state to negotiate these treaties. From an Indigenous point of view, First Nations saw those treaties as a new relationship, a way to adapt to changing economy, changing circumstances, a way to provide the resources and support that they needed in these historic contexts. So you can see here, Treaty 9 was negotiated in the early 1900s, 1905 to 1906, and then in a later period. And the state wasn't really interested in negotiating a treaty there until there were mining resources. There was increased interest in mining resources in that area. Treaties 1 and 2, that from the state perspective, they were interested in negotiating treaties when Indigenous peoples prevented Western settlement from proceeding further west of Portage la Prairie in Manitoba. And you can see like how even by Treaty number 11 in 1921 up here in the, which covers most of the Mackenzie Valley in the north, the state didn't consider this land very desirable or useful for agriculture or European settlement. So they weren't really interested in negotiating a treaty until 1920, when oil was discovered at Fort Norman, and then the federal government moved to negotiate treaty with that idea of extinguishing the Indigenous title. So this is an image of Treaty 7 chiefs in signatories to Treaty 7 in southern Alberta. Treaty 7 was first negotiated in 1877, a period of rapid change for Indigenous communities in Western Canada on the plains. You see the decline of buffalo, the economy was changing. So Indigenous peoples really asserted and wanted to sign treaties as a way to adapt to those changing circumstances. They wanted to ask treaties, they wanted to ask for different things such as farming equipment, annuity payments, sets of clothing, provisions of schools, hunting, the securing of their hunting and fishing rights, the securing of a land base. Treaty 6 was signed with the famous medicine chest provision, which stipulated that the Indian agent at the time would have a medicine chest available to the community, including free rations in case of famine. So these things have been interpreted to mean today in things like the right to health care for all treaty Indigenous people, not just Treaty 6, or the right to an education, the right to hunting and fishing rights. So as I mentioned, the federal government saw these documents as final. They looked to the written record as a way to open up these Indigenous lands for settlement and to draw those territories into Canadian Confederation. But Indigenous people saw them as a part of a new relationship, a nation-to-nation relation, in which Indigenous people are equally involved in decision-making, and that they encompass those oral discussions that took place, and also the insistence that these agreements also require ongoing attention, renewal, and relationship building. So I'm going to fast forward again to 1973. The period, the early 20th century, we see federal policies, the height of assimilation policies, the height of the residential school system. 1927, the Indian Act makes it illegal for Indigenous communities to actually research and file land rights through the courts, and so in the post-war period we have the Nisga'a Nation and other nations across Canada, but the Nisga'a of northern BC start to come together and discuss their rights, and they decided to sue the federal government. So they brought their Aboriginal title case for a portion of their territory in northern BC to the Supreme Court of Canada, asking for a declaration that their Aboriginal title had not been extinguished. So in 1973, the courts said there was a split decision. 3 judges decided that the Royal Proclamation extended to British Columbia and legally affirms that the existence of Aboriginal title. The Nisga'a owned their territory, had not been extinguished through treaties. 3 judges decided that the proclamation did not extend to BC, and that if the Nisga'a did have title to their lands, it would have been extinguished through other colonial mechanisms such as logging licenses. And the final judge ruled against the Nisga'a on a technicality. But basically, this case was the first state court recognition that Aboriginal title existed in Canada, and it led to a new federal lands claim policy to negotiate modern-day treaties throughout Canada, which are also called comprehensive land claims agreements. So we have the first modern-day treaty in 1975 with the James Bay and Northern Quebec Agreement. in 1993 in British Columbia, where few historic treaties had been negotiated. Following Oka, the province and the federal government and First Nations set out a new modern day treaty process specific in BC, and over 40 negotiation tables were initiated. You can see there's only 4 treaties that were negotiated through this process, and many First Nations in the province criticize it in terms of the province and the state's interest in extinguishing title and rights. So just a quick overview of these modern treaties. I also wanted to highlight that Section 35 of the Constitution Act of 1982 also recognizes and affirms Aboriginal and treaty rights. So it states the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. In this act, Aboriginal peoples of Canada includes the Indian, Inuit, and Métis peoples of Canada. So I want to stress that the Constitution, this section came from the activisms and assertions and hard work of Indigenous peoples across Canada that led to this section being included in our Constitution. But that it recognizes and affirms those rights. It does not create them. The state does not give treaty rights to Indigenous peoples, but they are coming from those Indigenous traditions and governance systems. They are inherent to those systems. So I also wanted to highlight the United Nations Declaration on the Rights of Indigenous People, which was ratified at the United Nations in 2007, which also provides Article 37. Indigenous peoples have the right to the recognition, observance, and enforcement of treaties, agreements, and other constructive arrangements concluded with states or their successors, and to have states honor and respect such treaties, agreements, or other constructive arrangements. So this declaration again came out of a global Indigenous rights movement that emerged strongly in the second half of the 20th century. Globally, making those connections and led to the declaration, which I mentioned was ratified in 2007 and has not been adopted into Canadian federal legislation or implemented in our legislation. But another important recognition, affirmation of those rights. So in conclusion, I just want to highlight that historically, again, this from the state perspective, have seen treaties as ways to extinguish, eliminate Indigenous title, to facilitate peaceful settlement and resource development. Historically, from an Indigenous perspective, treaties are not final or permanent documents, but they are agreements between nations subject to changing, conditions that call for negotiation and renewal. So even those pacts, early pacts of peace and friendship undertaken to last forever between First Nations, had to be renewed from time to time with appropriate ceremonies to keep them alive. Treaties were more about defining those ongoing relationships and continuing obligations and responsibilities. So I'd like to just end with this clip from the film Trick or Treaty by Annie Sabamswin. This is a clip of Stan Lutit, who is the Grand Chief of the Muskogowik Tribal Council in James Bay, Northern Ontario. And it's a meeting of the Muskogowik Cree of James Bay about the terms of Treaty 9, which and the discrepancies between the written record which says that the treaty is about Indigenous signatories surrendering, ceding, extinguishing. It uses a lot of this language, land rights, and the oral histories from the community, which are corroborated with other historic documents of the time that highlight how the treaty was understood by the Cree and Oji Cree negotiating the time as part of this ongoing relationship, as a way to provide support to these communities. So I'll just ask to play that clip, which is about 2 or 3 minutes. Thank you.
This is good stuff. And it's what we've been saying all along. Finally, we're getting evidence. Finally, we're getting support in terms of how the treaty was really presented, how the treaty was really understood by our forefathers. That's good stuff. Because now we know, our elders all along, they've been saying, we never gave up our land. How true that is. How right on they are about that. People like Emil Nakuji, Willie Stevens, Go Xiuwen, Monroe Linklater, Thomas Archibald, all these elders that we know, Andrew Wesley, that said that all these years. And now Chief Norm is saying that. Grand Chief Yesno is saying that. I'm saying that. Our chiefs are saying that. We're right. We were right all along. And Duncan Campbell Scott, he's standing in front of the government of the day and speaking on the creation of a bill to implement the Indian residential school system in Canada, 1920. And he said,
I want to get rid of the Indian problem. I do not think, as a matter of fact, that the country ought to continuously protect a class of people who are able to stand alone. Our objective is to continue until there's not a single Indian in Canada that has not been absorbed into the body politic, and there's no Indian question and no Indian department. That is the whole objective of this bill.
and he's the same guy who sat down with my grandfather to talk about the treaty. And the sad part is, 2013, is there Duncan Campbell Scots who think that way in Toronto, Kingston, Ottawa, Montreal, Ottawa? You're darn right there is. There's people, unfortunately, that still have that mindset. And that's why we got to continue talking about the treaty. That's why we got to continue talking about the good things that came out of it and our understandings from our elders in regard to the treaty. That's why we need to educate not only ourselves, we got to educate the general Canadian public about the treaty, because the treaty is not something that you should be scared of. The treaty is it's something that we should all benefit from, and it's a good thing. We're all treaty people. Non-native people are treaty people too, because your governor represented you, and you need to learn about what was said and what was done and what was done wrong and what was done right. So I think we got a lot of work to do.
On January 24th, 2013, Chief Teresa Spence agrees to end her 6-week-long fast with the condition that a declaration of commitment on the part of the government be presented by the Assembly of First Nations, consisting of 13 points that address the betterment of First Nations life and the recognition of their treaties.
Remember that we're here together and we're here for our people, especially the youth. You know, the youth look up on our leaders, so it's really important to remember they're watching leaders. You know, it is their future, and we have to protect the treaty rights and the relationship. Again, I just want to say thank you to all the chiefs and to the grandmothers and the women, even the children that came to Victoria Island, giving us encouragement words.
Chief Spence fights for the rights of all Indigenous people. There is a special place in her heart for children and the youth, and they know it.
Okay, Megan.
James Bay on the...
Okay, there we go. Thanks. Great, thank you. So I wanted to end with a clip from the film from Chief Lutit, who's talking about the importance of non-Indigenous Canadians to learn about the history of those treaties and to understand those contexts. And I think that it's a really powerful film as well, looking in terms of the history of Treaty 9 in the context of the Idle No More movement. And you saw Chief Spence, Teresa Spence at the end there from 2014. So thank you for listening. And I think we have some questions now.
Thank you so much, Susan. Thank you to everyone who was able to join us. My name is Tara Sutton, so I'm really happy to support today's event and moderate the questions. We've had some questions that came in advance of today's Lunch and Learn, and then we've also had some that have come in while Susan, you were presenting. So I'll maybe start with the ones that came in while you were presenting. We're wondering if you can explain terra nullius again and a little bit deeper.
Sure. So that concept of terra nullius, which is a part of that Doctrine of Discovery, so is that idea that Indigenous lands are unoccupied. So you see this really clearly. I'm not saying that Indigenous lands were unoccupied. They're not, like, people are living in these places, but you see this enacted really clearly in the Australian context. So the whole, when the British went to Australia, they enacted this concept, this legal concept of terra nullius, saying that Indigenous people didn't live there, there weren't people living there, as a way to assert their sovereignty over what is now Australia. So there was a really important court decision in Australia called the Mabo case, which is from the 1990s, which overturned that idea of terra nullius. So it's kind of crazy to think that Indigenous people also have to take states they're there. So that concept also gets this idea that the land is empty or that it has been abandoned or is not being used so supposedly properly. Like, so that idea, you can see how that notion is also taken up in lots of racist representations of Indigenous peoples as well in history. If you think of the concept of the vanishing Indian, this idea that Indigenous peoples wouldn't survive modernization or the supposed onslaught of civilization, that they would reach the darkness. Do you know the film Dancing with Wolves? I think it's from the 1990s with Kevin Costner. You know, the final scene of that movie is the Sioux kind of retreating into the distance, moving further and further west as American settlement moves across the United States. So that's kind of this example idea of abandonment or this empty land. So that's a Western European concept that is used to justify European settlement and use of land in different ways too.
Great, thank you so much. Second question that came in, how has the ratification of the UNDRIP affected the current standing of treaties? If the UNDRIP, is included in Canadian law, will this ultimately affect the Indian Act?
So that's a really big question. That's a great question. I don't have the answer for that, but I think like the UNDRIP, the UN declaration. So you may know that there was MP Romino Saganov submitted a private member's bill so that the so that Canada would implement the declaration and align it with our legislation, which was rejected at the level of the Senate. The BC provincial government has implemented the declaration within the last year. I don't know that there's been lots of criticism about it not really making a difference in terms of relations or consultations in that province. This would be a great question to ask Phil and Chief Laforme, I think, over the next couple of days as well, and bring to our discussion on Friday. The thing about the declaration, you know, it's part of international law, it sets a standard, but it doesn't necessarily have teeth in Canada unless we can adopt it as part of our legislation. It covers a range of human rights of Indigenous people, but also Indigenous rights and treaty rights that are distinct to Indigenous peoples as well. So that's a great question. I don't think I quite answered that, but we could look at that again over the coming days as well. Thanks.
Great, thanks. Next question, what is the response to those who say that some agreements were made by band chiefs as compared to original treaty agreements, which were the desire of hereditary chiefs? Which agreement then holds?
Well, this is also a big issue in Canada. We can see this with, excuse me, with the Wet'suwet'en in northern British Columbia. So with the pipelines last winter, so with the Wet'suwet'en protests and camps set up in Wet'suwet'en territory. So we have an agreement where the pipeline's running through an Indigenous territory, and that was made with elected chiefs. So elected chiefs, as you may know, come under the Indian Act and have jurisdiction over Indian reserves, which are a small portion of an Indigenous traditional territory. So that jurisdiction over the reserve, so with a pipeline running through Wet'suwet'en territory, which comes under jurisdiction of those hereditary chiefs through the clan system and the house system within that nation. So the negotiations weren't done with the hereditary leadership, but with the elected leadership who don't have jurisdiction over those larger territories. So it creates a lot of confusion, I think, and conflict. So yeah, so some Indigenous commentators talk about how it's important to have those conversations among those two groups as well. In some cases, the elected leadership aligns with the traditional leadership. So, you know, every situation's a little bit different in terms of what that looks like. But yeah, it causes a lot of confusion and conflict, and you know, it's really important to understand what those governance systems are and what they look like traditionally as well. So tomorrow you'll have Phil Montour speaking, who could also talk about that in terms of Six Nations. So Six Nations hereditary leadership was actually in 1923, the RCMP came into Six Nations and put into place that elected leadership and removed the matriarchal hereditary chiefs. So yeah, these are important discussions within those nations as well, and are very complex. So yeah, I think it's critical to learn and understand about each situation and really listen to those Indigenous communities leaders about that issue.
Thanks, Susan, and I think that's a great idea to continue the conversation tomorrow night with Phil. Okay, this was a question that had come in advance. I have often heard that we are all treaty people, but to the best of my knowledge, there are parts of Canada which did not make treaties with the people who are Indigenous. As a personal example, my Inuk/Mi'kmaq father was born in Newfoundland before it became part of Canada. I'm not aware of any treaties there. Neither am I aware of treaties for any of my Inuit relations. So how are people like me descendants of the disenfranchised treaty people?
Well, that's a great question, because we do hear about this, we are all treaty people, and I talked about that today as well. So most of my work has been with in British Columbia, which, as I mentioned, is also not subject to treaties, except for a small portion of the northern part of the province. Treaty 8 reaches into the northern part of the province, and then those Douglas treaties that were negotiated when during the colonial period, which encompass small portions of territory around Victoria and on Vancouver Island. So it's interesting because coming from BC, people don't talk about treaty. People don't talk about treaties. This phrase, we are all treaty people, I only started to hear when I came to Ontario. But we talk about being guests on unceded lands, on the lands of the traditional ancestral lands of those particular nations in the province, about being uninvited guests, like from a settler perspective. From the Indigenous perspective there, I'd say like that people, there's the modern day treaty process, the comprehensive claims process that non-treated areas, some nations have decided to negotiate modern day treaties. But many nations in BC aren't interested in negotiating treaties because they can operate in a way that just us, in terms of asserting their rights, without having that formalized agreement. The other side of this is that if we think of ourselves, I'm not saying Indigenous people think of themselves as Canadian citizens, but settlers think of themselves as Canadian citizens living in a non-treaty area. As I mentioned, the Canadian state has been developed through the negotiations of treaties and through that relationship with Indigenous nations. So in that sense, being a settler or a new immigrant to Canada is a part of understanding this history of how treaties have contributed to that formation of the nation state, and also those dispossession of lands and access to resources as well, and ways to reverse that, to reclaim land and resources, and what are the processes in terms of supporting those kinds of actions and assertions from Indigenous nations. So I don't, like in terms of the Innu example in Newfoundland, I don't really have any experience there or insights there, but from what I've seen in the province of BC, people are asserting their rights, their nationhood, their sovereignty outside of those systems, outside of that relationship with the state as well. And we see lots of examples of this across Canada as well, of Indigenous communities, individuals, nations asserting sovereignty outside of the state relationship too. So that's a great question, and also something to continue to talk about in terms of what does that mean, being that we are all treaty people.
Thanks, Susan. Okay, we only have a minute or two left, so this will unfortunately have to be the last question. Curious to learn about the steps forward to recognize Indigenous laws and governance as a step toward addressing land back obligations. What are the opportunities for holding the Crown accountable at the UN as we held South Africa accountable during apartheid?
So also a great question, a huge question. So I feel like, you know, it's really important as settlers to take direction from Indigenous peoples, activists, nations, communities, in terms of what our role is and what those steps are. So again, like a question that we could continue to talk about this week with our other speakers. And also just thinking about like the ways that Indigenous communities have strategized this, and you know, we have people working at the level of the United Nations, which is really critical. You know, have worked to develop that declaration, have ongoing meetings there, assertions there. We have nations going to court over and over and over again, trying to assert these rights as well. We have blockades happening when communities get frustrated. So we have petitions. We saw the petition of 6 nations to King George. So a whole range of kinds of activities and strategies that Indigenous communities are employing. And I think that it's really critical to kind of be aware of what's happening and ways that settlers can support those kinds of actions as well. You know, which often means kind of being in the background, providing support, and really listening to what Indigenous nations are telling us. So great question. Also something that we can continue discussing this week as well.
Thanks. Thank you, Susan. And we will also carry forward the questions we couldn't get to today, and I do apologize for not being able to get to them, but some great discussions nonetheless. I'm going to hand it now to Robin Stadelbauer. Over to you, Robin.
Hello, Ani. And I'm here to wrap up, and I want to say a big chimigwech to Susan. Thank you so much for sharing your knowledge with us and presenting an excellent and informative presentation. You gave us a lot of information to consider and digest. A highlight for me, I won't get into the details. I had written out a larger note that I wanted to say, but given the time, I want to just highlight that what stood out for me, a lot did, but the context and perspective and the approach that Indigenous and non-Indigenous came to these treaties with is something that really stands out for me as something that's really important to consider as we all learn about Treaty Week. So thank you very much, Susan. I really appreciated your presentation, and thank you for sharing with us. And I want to say thank you to everyone else who joined us today. I hope you enjoyed your time with us. We hope that you will stick around and join the rest of Treaties Recognition Week. The descriptions and the links can be found on the Treaties Recognition page, and if you have any trouble finding them, you can just let us know. So Gawabamin Minwa, which means see you again in Anishinaabe. So thank you. Miigwech.